This is not just loud music, says the Florida Supreme Court. It's also freedom of expression protected by the Constitution. Hello, everybody. As if the shooting death of a Wolfson High School student over loud music was not senseless enough already, a new ruling by the state Supreme Court makes it appear even more senseless.
The justices unanimously upheld two lower court opinions which struck down a 2007 Florida law prohibiting loud music while driving. It was loud music coming from an SUV at this Southside gas station last month that police say led to the shooting death of 17-year-old Jordan Davis. Today, the charges against the accused killer, Michael Dunn, were upgraded to first-degree murder. More on that in a few minutes. But first, Channel 4's Adrienne Moore is joining us live. She's spoken with a lawyer for the Davis family about what impact, if any, this ruling could have on the case against Dunn. Adrienne?
Mary and Tom, good evening to you. The Davis family attorney tells us tonight that this ruling speaks loud and clear, especially, he says, when it comes to reinforcing the idea that Jordan Davis and his friends weren't doing anything illegal when they cranked up their music. You can crank it up, blast it, or make your speakers rattle, because a new ruling by the Florida Supreme Court says you can now play everything from techno to Timbaland as loud as you want.
This law will never pass strict scrutiny unless it is absolutely necessary to achieve a vital state goal.
In a 7-3 vote, the justices struck down the current state law that bars drivers from blaring the volume on their radio 25 feet away from someone, stating the language is too broad and violates free speech. The court's decision is also turning up the talk from attorneys in the high-profile murder case of Jordan Davis, who say Michael Dunn shot and killed him after an argument over loud music while he was riding in an SUV with his friends.
It's not going to hamper it. If the defense on the other side was thinking about using it as a defense, I think that's going to hurt their case. It will reinforce the fact that these 4 kids weren't violating the law.
But regardless of the high court's ruling, legal experts say there's another version of the law that could go on to pass on a different legal beat.
The state legislature will sit down and draft another similar law that is less broad and less vague, so that it will pass constitutional scrutiny.
And legal experts say a number of people who have been cited for loud music over the last couple of years could ask to have those citations overturned as well, but they don't really anticipate a big backlash with this, mostly because those tickets are generally under $100. Reporting live tonight in Jacksonville, Adrienne Moore, Channel 4, the local station.
Adrienne, what about the attorney who first went before the Supreme Court on this issue of loud music? Have we heard anything from him on today's ruling?
We did, in fact, Mary. The lawyer at the heart of this, his name is Richard Catalano, and he says that he is delighted by this decision. In fact, he was quoted as saying, "I'm not trying to sound arrogant, but yes, I expected to win. I don't know many attorneys that are worth their salt that don't expect to win." Now back to you.
Thanks, Adrienne. Well, as we mentioned a few minutes ago, Jordan Davis's accused killer is now facing new charges. A Duval County grand jury has indicted Michael Dunn for first-degree murder in the shooting death of Davis. He's also now charged with 3 counts of attempted first-degree murder because there were 3 other people in the SUV. He faces a 5th charge of shooting or throwing a deadly missile into an occupied vehicle. Tom is now joined by local defense attorney Gene Nichols to give us some perspective on this, where this case stands now. Tom?
Gene, thank you very much for being here with us this evening. This started with a charge of second-degree murder, and State Attorney Angela Corey took the evidence that she has gathered from her own investigation and from police, and she took it before a Duval County grand jury. What would she have shown the grand jury, which of course the proceedings are secret, but what would she have shown the grand jury that would have led them to return a murder 1 indictment?
Well, clearly, Ms. Corey believed that she had the grounds and the evidence to establish a murder 1 indictment, and in order to charge Mr. Dunn with first-degree murder, she had to bring that in front of the grand jury, which is what she did. Tom, you're exactly correct. What was brought before the grand jury, we don't know, but clearly, based upon what they have come back with, which is the first-degree murder indictment, we know that the evidence establishes, at least for the charge, that the actions that Mr. Dunn took were premeditated. Most likely, They're focusing on the fact that what we have heard is that after the altercation happened with the young men, just with the talking back and forth, that he went back to his car to obtain a weapon. In order to establish first degree, there has to be premeditation. So Ms. Corey must have believed, as a grand jury has found, that the actions that he took, he had the time to think about what he was doing, went back to his car, came back, and then fired the weapon.
So premeditation does not have to be a protracted period of time. It can be a couple of minutes even?
It can be much shorter than that. It can be long, it can be short, but it will be a determination as to whether or not he had enough time to make a decision to try and take these young people's life. And Ms. Corey believed, as now the grand jury believes, that he had the time just from going back to his car to grab his gun to come back again, that that's what his intent was, and that's why we're here today with this.
Now, in terms of Michael Dunn, this is a much more serious trial, a much more serious case. What are the possible penalties? So this could be life in prison for him, couldn't it?
It will be life in prison if he is convicted. For a first-degree murder charge, you're either facing the death penalty, which at this point in time it appears Ms. Corey is not going to be going after, or we're going to face a mandatory life in prison. So there's no question the stakes are as serious as they can be.
We heard some comments from his original defense attorney about the possibility of a stand-your-ground defense. It certainly would appear that the state attorney's office doesn't expect that a stand-your-ground defense will stand up.
Well, Ms. Corey is not going to make a decision to go to the grand jury based upon what the defense might put forward. She is not going to waste time guessing what the defense might do. She believed that she had the evidence to present to a grand jury for first-degree murder, so she's going to present it. If the defense decides to go that route, it would bother her for the basis of how she's going to go out and prosecute a case. So it probably to her decision with the evidence she had.
Nichols, thank you very much for your time, for coming in this evening.
Absolutely.